So today we're going to look at examination of a witness at a civil trial. So at a civil trial, when a witness is called to the court and taken into the witness box, the first thing that happens is that the registrar of the court would have the oath administered to the witness. So the witness is going to swear that they would give, testify, and give the truth to the court, the whole truth, and nothing but the truth. Of course, there are some witnesses who would not be made to swear the oath, like a witness who, by reason of their religious beliefs, does not swear, and also a child under the age of 14 years, because children under the age of 14 years give unsworn evidence to the court. So for those who do not swear by reason of their religious beliefs, they would simply need to affirm to speak the truth. While children under the age of 14 years, the court would simply put some questions to the child to see if the child has sufficient intelligence to understand those questions and understands what it means to speak the truth. And then the court would take the evidence of that child. But after the witness has been sworn, what happens next is that the registrar now would caution the witness, right? Would tell the witness, if you tell a lie or willfully mislead this court, then you're liable to be prosecuted. And if you're found guilty, you'll be dealt with according to law. Now, after the registrar cautions the witness against committing perjury, that's lying on that oath, now the registrar will make an announcement in the court that if there's any other witness in the courtroom, they should leave the courtroom so that their testimony would not be influenced by what they hear this witness say. Now, if a witness fails to leave the courtroom, then it doesn't really mean that when that witness now has to testify, their testimony will be inadmissible as evidence. It simply would mean that the court would attach little weight to their testimony, which means it would not be very reliable again in the court's view. All right. Now, there are three stages of examination of a witness. All right. We have examination in chief, we have cross-examination, and then we have re-examination. So examination in chief is the first stage of questioning of a witness at trial. And this is where the lawyer who has called the witness would put questions to the witness in order to get the witness to provide material facts to support their case. How it begins is that the lawyer would usually ask the witness introductory questions, ask the witness to talk about, to tell the court their name, their address, their occupation, that sort of thing. Now, after asking the witness introductory questions, and the next thing that the lawyer does at a civil trial would be to try to get the witness to adopt their written statement on oath. Now, before trial, the witness is expected to have made a sworn statement at the court registry in which they would basically state all the facts that they know about the case. So the testimony they intend to come and give a trial is providing that statement. Now, at trial, when the witness is called, the lawyer simply tries to guide the witness to adopting that statement, all right, as their testimony for the trial. Okay, now how does the lawyer do this? The lawyer would set out by asking the witness first, do you remember making any statement? And the witness would answer, yes, I do. And then the lawyer would ask the witness, where is that statement? And the witness would say, I believe you should have it. And then the lawyer would ask the witness, if you're shown that statement, would you be able to recognize it? Can you identify it? And the witness would say, yes. And then the lawyer would say, how can you do that? And then the witness would say, I signed the statement, my signature is at the bottom of the statement. And then with the court's permission, the lawyer would now show the statement to the witness and ask the witness, is this your statement? And then the witness would identify it and say, yes, this is my statement. And then the lawyer would ask the witness, what do you want to do with this statement? And the witness would say, I want to adopt it as my oral testimony for the trial. And after the witness does that, the lawyer would now inform the court that the witness has adopted their written statement and oath as their oral testimony for the trial. And now the court receives it as part of the evidence before the court. And at this point, the lawyer is done questioning the witness, apart from if the lawyer wants to tender any documentary evidence through that witness. The lawyer is done with the witness for examination in chief. Now, the opposing lawyer can begin to now cross-examine the witness on the content of the statement. All right, so this is what primarily happens during examination in chief. I hope you've enjoyed learning, and I'll see you to talk about cross-examination and re-examination some other time. Bye-bye.